Section 5. Signature by mark. A person who cannot write his or her name still can acknowledge his or her signature on a document or subscribe and swear to an affidavit by making a mark. California Civil Code, Section 14. To perform a notarization with a signature by mark, the notary public still performs the steps required for the appropriate notarial act, such as an acknowledgment or jurat. The notary public must use the appropriate form as well. The notary public must confirm the identity of the person making the mark by satisfactory evidence. California Civil Code Section 1185. The notary public also must perform the following additional steps. If the signer must acknowledge his or her signature on a document, the signer can make a mark where his or her signature should be in the presence of the notary public, or can acknowledge that the mark in the place for a signature is his or her mark. Note that the mark does not need to be an X. If the signer is subscribing and swearing to an affidavit, the signer must make a mark where his or her signature should be in the presence of the notary public. Note that the mark does not need to be an X. Two witnesses must observe the signer making their mark and must sign their names next to the signer's mark on the document. One of the witnesses must write the name of the signer making the mark next to the signer's mark. The signer also must make his or her mark as the required signature in the notary public's journal. The making of the mark in the notary public's journal must be witnessed by a person. The witness must sign his or her name next to the mark and write the name of the signer next to the mark. The notary public can serve as the witness for the signer's journal signature. The witnesses only are verifying that they witnessed the individual make his or her mark. A notary public is not required to identify the two persons who witnessed the signing by mark or to have the two witnesses sign the notary public's journal. Exception. If the witnesses were acting in the capacity of credible witnesses in establishing the identity of the person signing by mark, then the witnesses' signatures must be entered in the notary public's journal. Following are examples of a jurat and journal entry for a signature by mark. Section 6. Certifying copies. A notary public can certify the copies of only a few types of documents. The notary public only can certify copies of powers of attorney, California Probate Code, Section 4307, California Government Code Section 8205A4, and copies of his or her sequential journal or portions of the journal in response to a written request of the California Secretary of State or a subpoena or court order. California Government Code Sections 8205B1 and 8206E. Certified copies of birth, fetal, death, and marriage records can be made only by the state registrar, by a duly appointed and acting local registrar during their term of office, and a county recorder. To certify a copy of a power of attorney, a notary public must compare the original power of attorney document and the copy to make sure the copy is exactly true and correct, or make a copy of the original power of attorney document. Attach a notarial certificate to the copy stating that the copy is a true and correct copy, and complete a journal entry. A certificate A suggested form of notarial certificate for certifying a copy of a power of attorney is shown below. The first part of the certificate indicating in what county the notary public and person requesting the certified copy are located is the venue statement. The venue statement establishes where the notary public performed the certification and where the person requesting the copy appeared before the notary public. The state is always California, since the notary public has jurisdiction only within California. The county is the county where the certification was performed. That is where the person requesting the certified copy personally appeared before the notary public and presented the original power of attorney for a certified copy. Since a notary public may provide services anywhere within California, the county in the venue statement may not necessarily be the county where the notary public maintains his or her principal place of business or the county where his or her oath and bond are filed, but must be completed with the actual county in which the notarial act took place. The notary public must insert his or her name and the day, month, and year the person requesting the certified copy personally appeared before the notary public, and the notary public compared and certified the copy of the power of attorney. Then the notary public must sign and stamp the certificate with their notarial seal. B. Journal entry. A notary public must record the following details in their sequential journal each time the notary public certifies a copy of a power of attorney. California Government Code, Section 8206A. Best practices tip: to ensure completeness for a later request for information related to this type of transaction, the notary public should also record the name of the person who is requesting the certified copy, the name of the agent appointed by the power of attorney, and the person who signed the power of attorney, the principal. Time and date of the act. The type of notarial act performed was certifying a copy of a power of attorney. The fee charged for the notarial act. Section 7. Immigration documents. A notary public can notarize the signature on a document affecting the immigration or citizenship status of any person. California Government Code, Sections 8205 and 8223. The notary public cannot assist a person in completing any immigration document except for the signature and date. Only an attorney, a representative accredited by the U.S. Department of Justice, or a person who is registered by the California Secretary of State and bonded as an immigration consultant under the California Business and Professions Code, may assist a client in completing immigration forms. California Business and Professions Code, Section 22,440. Only an attorney can advise a person regarding which immigration document or form the person should complete, or advise how the person should answer questions posed by an immigration document or form. If a notary public is also a California registered immigration consultant, that notary public may assist a client by inserting the answers given to the consultant by a client. California Business and Professions Code, Section 22,441, Subsection A, Subsection 1. California Government Code, Section 8223. A notary public who is also a registered and bonded immigration consultant may charge $15 per person for completing a set of immigration forms. A notary public also can charge an additional fee for each notarial act performed in relation to a set of immigration forms. California Government Code, Section 8223. Please note that special rules apply to notaries public who are also immigration consultants or advertise their services in a language other than English. A notary public is barred from advertising in any manner whatsoever that he or she is a notary public if the notary public also promotes himself or herself as an immigration specialist or consultant. California Government Code, Section 8223. A notary public who is not a licensed California attorney and advertises notarial services in a language other than English must post with the advertisement both in English and the other language that the notary public is not an attorney and cannot give legal advice about immigration or any other legal matters. The notary public also must list the statutory fees that a notary public may charge for notarial services. California Government Code, Section 8219.5. In many countries outside the United States, an individual must be a duly licensed attorney before he or she may obtain a notary public commission. In Latin American countries, the phrase notario publico implies that the person is a practicing attorney in that country, which is not the law in the state of California. Under California law, a person may be appointed and commissioned as a notary public without being a licensed attorney. Therefore, a notary public cannot translate the term notary public as notario publico or notario into Spanish, even if the prescribed notice is posted. California Government Code Section 8219.5. A first offense for a violation of this law is grounds for the suspension of the notary public's commission for not less than 1 year, or revocation of a notary public's commission. A second offense is grounds for the permanent revocation of a notary public's commission. California Government Code, Section 8219.5. Example: Catherine Consultant is a notary public and has been registered and bonded as a California immigration consultant. Mikhail and Irina visit Catherine to obtain assistance in completing citizenship forms. Catherine's business cards say she is a notary public and an immigration specialist. Catherine enters information into the citizenship forms that Mikhail and Irina provide and enters information she knows from her own experience and education as an immigration consultant. For these combined services, Catherine charges Mikhail and Irina $100. Catherine has broken a number of laws. She cannot hold herself out as a notary public in her advertising because she is an immigration specialist. Catherine cannot enter information into immigration forms on her own, and Catherine cannot charge more than $15 per person for completing the forms on behalf of her clients. Catherine can charge an additional notary fee for any notarial services if she limits herself to completing the citizenship forms with only information provided by Mikhail and Irina, but can charge no more than the statutory $15 for each signature notarized. The permitted statutory fees are less than the total Catherine charged Mikhail and Irina.